Ben Allgrove, how are you this afternoon?
Very well, thank you, Ted. Thank you.
Really appreciate you coming on. You're coming to us from London, correct?
That's right. So, based in London, I'm Australian originally, but I've been here for the last 20 plus years. So, I think I'm a Londoner for all intents and purposes.
Okay. Yeah, my team is actually over there for Legal Geek this week.
Indeed, indeed.
Are you going to make it?
I'm not making it. Members of my team are making it this time round, but it's a good event.
Yeah, yeah. It's our first time there. We're somewhat new in the UK. We're growing in that direction, but yeah, we're excited about it. Well, before we jump into our agenda, let's get you introduced. So you're the Chief Innovation Officer at Baker McKenzie. God, I don't know what I think you guys are on the AmLaw list, correct?
That's right. That's correct. Yep.
You're American based. I know you're at the top of the list based on your size and scale, but why don't you tell us a little bit about who you are, what you do, and where you do it?
Yeah, thanks, Ted. So I'm a practicing lawyer. So I'm a technology lawyer by trade. And before I came to private practice, I was an academic, an AI academic, which is what I was doing before I came into private practice law. So I still do the client work. I still advise, a variety of technology companies on various forms of regulation, including AI regulation. But my management role at the firm is, as you say, as the Chief Innovation Officer. So I'm the firm's first Chief Innovation Officer. And in that role, I advise our management and our partners on, not only our strategy when it comes to innovation, and these days, most of that is AI, let's be honest, about the conversation. But equally, I'm the one who engages with leads the engagement with our clients, with the market around where the legal profession's going, where our strategy is to respond to that, what I think clients need and are asking for. And that's in the context of a firm which, as you say, is a large international law firm. It was the first international law firm. It's not the biggest anymore, but we are relatively sizable. And we're quite proud of the fact that although we were founded in Chicago, so I do think we have we do have American roots. Our second office was Caracas in Venezuela. So we are sort of the definition of an international business. So yeah, that's my role.
Interesting. And how long has the innovation function existed at Baker McKenzie?
So we sort of set up our first sort of name strategy in 2016, 2017, like lots of firms did about that period of time, that sort of first phase of legal tech impacting the market. My role specifically has been around for just over, well, it's actually nearly 4 years now. I was about to say just over 3, but time flies. I've been involved since 2016, 2017, but the Chief Innovation Officer role was brought in about 4 years ago now.
Yeah, I've been around long enough to remember when legal innovation used to be an oxymoron, like jumbo shrimp or military intelligence.
Yeah.
Times are changing, which is a great time. So we're a legal tech company, and it's an exciting time from a vendor perspective. It's a little scary too, because the future of law is a little bit uncertain. I think there's a bright future. It's just we don't know exactly how the dust is gonna settle, and we're 100% dependent on law firms as our client base. So, I started this podcast shortly after ChatGPT was released, and it really had nothing to do with AI. The reason I started the podcast is because I was honestly confused on the innovation function within legal. I had seen many knowledge management roles kind of get rebranded with the innovation title, and when I talked to certain people, the remits or the responsibilities of those roles hadn't changed that much. So I started off with a couple of folks in your seat at other firms and just, hey, tell me, let's talk about the divergence or convergence of legal innovation and KM. How does Baker McKenzie think about that distinction?
Look, I mean, I think it's an evolution. So I'm not going to say that we have necessarily reached endpoint or that we've got it all figured out. We've taken a slightly different approach to many of the firms in the market. As you rightly note, in lots of businesses, the role has traditionally sat in technology or in knowledge, or some sort of adjacent function within the business services side of the business. when we set this up, we put, a practicing lawyer and a partner into that lead role. Now, obviously, I'm supported by a sort of a team of business professionals across the business, but we felt it was really important to have a partner in the role for two reasons. So one was somebody who was close to clients and close to what was happening in the market and have that direct sort of entry point. And then also internally as a change agent, if that's the role and it's the role that our management wanted, was somebody to challenge established business models, established thinking, that is an easier thing to do in a partnership if you are a partner. And that, we hate the term non-lawyers, but the reality is that is the dynamic, I think, in most partnerships. And so for that reason, we set it up in the way that we have, with me sitting in that role. I don't think I will forever be in the role. I certainly don't want to be in the role forever. And I don't think necessarily the person who succeeds me needs to be a partner once we get the ball rolling or where we need it to be. But certainly for this initial period, it's been useful to have it structured that way.
Yeah, and I wrote an article on LinkedIn and mentioned
I saw that.
you
Yep.
and others, and I'm an advocate. I think you're exactly right. I think there are definitely advantages, and just a little background. So I've been in legal tech for almost 20 years, and have done business with more than half the AM law, and had a good cross-sectional view of the innovation function and the inner workings and the dynamics and the buying patterns and how firms implement technology. And so I've had an interesting perspective, and I think that the current state of legal, there are advantages to having a lawyer. Doesn't necessarily have to be a partner, but in that role, because it does give some street cred, and you're asking people to change what they do, and that's not easy, especially in an industry like legal that has been so. It's a very traditional, tradition runs strong in legal, and it's a very past precedent focused discipline. It's also very artisanal. There's not a lot of standardized processes that run across all practice areas on the practice side. Certainly on the business of law side, there's lots of standard practice or processes. But yeah, it was a fun debate to have with some people who I really respect, and we debated that. And I think that in the future, we could end up in a place where it's not as advantageous if we become more standardized in the delivery of legal services, and having someone in with maybe a Lean Six Sigma, or maybe it's a technology background, not necessarily a lawyer. But I don't know how do you see things playing out?
Look, I think it does depend on which bit of the market you're playing in, because coming back to one of your earlier comments around, this is a sort of transitional moment for the profession, which I agree with. But ultimately, the opportunity that exists for law firms and vendors to law firms and alternatives to law firms, is determined by what the buyer wants, right? What the client wants. And the reality is, despite the fact that in 2016, 2017, the same articles were being run saying, AI is going to kill the law, it didn't happen. We're still seeing an industry that's growing. Now, I am a believer that this time is different, and there's a variety of reasons I think it is different. So I'm not trying to deny that there is going to be a foundational impact on the economics of the legal industry and the delivery model. The reality is the conservative model has done very well, thank you, for the legal industry for time. And pure economics say that, but supply and demand, there is a lot of demand, and the supply has, delivered what was being asked. Now, clients don't like the billable hour. It's getting more expensive. The world's a much more volatile place. So actually the demand for legal services is going up. And what we have now are an increasing number of viable alternatives to the traditional delivery model. And that, I think, is what is going to shape up, what happens over the next few years. But ultimately, I'm a positive person around the fate of the industry, and certainly where we want to play, which is the premium end of the market. I think there will still be demand for that premium end service. which will still be white glove. I don't use the word artisanal, but white glove, because that's what our clients want, because they resist the standardization as well, right? And that's the simple reality for the things that they need. But there are layers of services which firms like us may or may not do, to be frank, going into the future, which are more susceptible to standardization, where the buyer is willing to accept the standardization, or where the technology allows a certain amount of customization on the top, like consumer products, but the core is standardized, that becomes the right delivery model. And so I think when it comes to, the roles that deliver that, that's going to be, you're going to need, we have plenty of people in our business with Lean Six Sigma and those sorts of process qualifications, and plenty of technical experts within our business. Whether they're the right ones to lead the function, I think depends on what the target is you're trying to hit. And I think you'll need a mixture of skill sets going forward.
Yeah, and I think that I agree with everything that you said. And law firms' financial performance have been consistently improving. Really since the recovery started from the Great Recession. AmLaw profitability sets new records every year. So the status quo is very sticky, and we're reaching a point of interesting tension where the stickiness of the status quo from the law firm's perspective, and you mentioned that that law firm clients don't like the billable hour. It's a love-hate relationship, right? It's they hate it, but also it's there's a lot of pearl clutching going on with respect to the billable hour. I hear it from pricing professionals where the conversation will start to head down the AFA path, and they want shadow billing to see their hours, and it's like as a professional service provider myself, the challenges with that are there has to be wins and losses as part of any sort of fixed price engagement. And fixed price really requires fixed scope, but you can't get into it like a does not exceeds type of engagement as a service provider. That's a losing proposition for a service provider, because what you've done is essentially say, okay, you're capping hours, but you're not allowing, if I generate some efficiencies, to recoup the losses that I had on the other X number of matters. And it seems like clients are still holding firms back from really charging down the AFA path. Is that your perspective?
So I think, and there are some notable exceptions to this in the market, but I think that proposition is true. But it's not because I think they're wedded to the billable hour from any sense of sort of affection for it. There is some type of work where that is the appropriate model for charging, right? There's a certain amount of sort of consulting heavy. If you want a specific person because they have a specific expertise, then actually charging for their time is not a bad mechanic for valuing that contribution. If you want an outcome, then it's a really bad mechanic for valuing the work that's done. But what the market has failed to deliver, again, despite thousands of conferences and thousands of speeches and articles, is an alternative means for valuing legal input. So if you take something like a big private equity transaction, people are perfectly comfortable with the banks taking a percentage of the deal as a mechanic for the value they bring to the table. Very reluctant to do that for law firms or other professional service advisors in the piece, even if it's a percentage of the value the banks bring, because obviously they bring the money. So I'm not saying it would necessarily be the same percentage. Question why? We've tried models where we have proposed tying our charging to the share price of a client, right? So being part of the collective success of the client. Again, reluctance to do that. Why? Because it's an indirect relationship between input and output. When it comes to it, and time is what people have used. But if you look back 50 years ago, the billable hour was not the dominant model for law firms in the market, right? It was a retainer model, largely. You had your law firm. What changed was actually the market started to become more fluid. There was more competition in the market. Companies didn't have just one law firm. They had panels, and so they needed to be able to compare them. And ultimately, that's where this metric came from. And you're right. If we want to come up with a different economics for the industry, we've got to get away from our sort of reliance on that as a measure. And I think there's, often people talk about the business model of law firms being the billable hour. The monitoring of what people do within the business by the way they spend their time, that's still going to be around for quite a while within a law firm, right? It's the same in most businesses, which are service business. You need to know what people are doing because to a certain extent you are monetizing their efforts. Whereas the pricing mechanic to the market is a different thing, related but different. And I think the pricing mechanic has to change long before it will change internally as to how many hours we're expecting associates to work, billables in a law firm. And clients could have got rid of the billable hour 20 years ago when this conversation really first started by putting out RFPs that said we want a price, but which didn't include what they still usually include, and we also want your rates, right? It's that second bit. Ultimately, they do control the market in a free market. And, that is the thing that I love leaning into client tooling to say, okay, yep, we can go compare the price. We can ask 5 firms what they would charge to do this thing and then pick based on, whatever our assessment is of value. But we don't need the hourly rate to compare those 5 firms.
Yeah, and what's interesting and what makes this such a difficult problem, I've heard, well, we'll just do value-based billing or outcome-based billing. It's really not that simple because what law firms deliver goes well beyond just the work product, and even really the advisory services that they provide. There are a lot of things kind of bundled up. There's reputation, there's trust, and decoupling these things and figuring out how to monetize them independently is very challenging. And, I saw somebody post the other day and I had a comment on it where they talked about we have to figure out what the client values, right? What in the delivery of legal work does the client truly value? And that answer will vary across practice areas and probably across clients. And so how do we unbundle these things and say we're going to charge you, a fixed price for the document, but we're going to charge you hourly, and for maybe the advisory work, and we think we should land here based on all of these intangible factors. It seems like a really difficult problem to unravel.
Yeah, look, it's a nuanced problem, but actually I don't think it's difficult. So the first piece that I think is essential is to recognize the point you made, which is it's more than just the delivery of the service. And actually, AI is a really good example of a change that's forcing that conversation, because in addition to brand and reputation and trust, one of the things that clients want is our insurance policies, right? And I don't think we should be shy about saying that. And so, we are now going into the market, and I should say this in consultation with our general counsel and our insurers, saying to clients, we can do this faster and cheaper, but we offer it to you at price X without the insurance policy, that you accept what you're getting under the tin and the level of quality assurance that goes with it, but you get a cost benefit and a speed benefit. Or we can use that same technology, but then wrap a human layer around it, which means it is more expensive and it's price X plus, but the insurance policy comes with that, right? Because we stand behind our quality control and our workflows to deliver that point, and therefore our insurers will stand behind us when we do that. We're still in a transitional phase. Clients are really uncomfortable with that conversation because they'll say, well, you're a top tier law firm. You should be able to, everything that comes from you should be right. And you go, yeah, but you need to understand the delivery model is different under those 2 outcomes. And the value to you is different under those 2 outcomes. And so there is a difference, not only in price, but also in the product that's being offered. And I think that's a conversation we're going to have to repeatedly have across the market for people to get comfortable with that. If they want to get the full benefit of the speed and the cost savings as well. The second, point I think that the market really needs to get their head around is the sort of win-loss narrative on a matter basis is not helpful for anyone, right? Ultimately, law firms are not charities, right? They have professional obligations and they have, duties of fidelity to their clients. So they're not a completely unregulated or a completely mercenary service provider. There is a difference. But ultimately, we are profit-making or profit-seeking entities. Our clients are profit-seeking entities, mostly, other than our pro bono clients. And we shouldn't be shy about saying, yeah, we need a return on capital that reflects the investment that's being made. And of course, we're going to seek to maximize that within reason. We could do a margin-based pricing arrangement, right? Again, if you want to be creative around it, you could say there's a certain margin frame in it as to what a reasonable margin is. But unless you're willing to go down that route, it's not your job as the customer to determine what the margin is on the fact that I build, a Rolls Royce or I build a Ford in respect of what the parts that go into that product are. That's an issue for me as the vendor there. And so I think thinking about it at a matter level, do I win on this engagement or not? The question is really, is the price that's being offered in the market for the quality I'm getting competitive with other vendors in the market? If the answer is it's too expensive, the market will sort that out. And if the market is too cheap, right, then you should snap that up straight away, right? Because that's a really good price. They've mispriced it in the market. But talking about the law firm winning, I think it displays a trust relationship, which is, I think, broken, but actually more fundamentally is the wrong conversation, because it's not about winning. It's about, there are different pricing models and different risks attached to those models and different scoping attached to those models. And if you only want to pay for the input that goes into the product, then actually we are back to the hourly rate, right? The input is there and there's a markup on the input and you pay for that. If you want the output, that is something where it's not a win-loss scenario. We've got to change that language as well, I think.
Yeah, I just had a visual when you were describing that about, essentially waiving cut. Like, I don't know how it works in the UK, but here in the US, when you go and rent a vehicle, and the optional, cover and all the places they make you initial, they make good margin on that. And yeah, that just brought interesting visual to mind.
Yeah, if you look at, yes, I mean, it's that visual, and I think that's fundamentally what we're talking about here. Because if you look at, some of the workflows that we've built out already for some new ways of service delivery, as a rule, we don't tend to make the output directly accessible to the client, right? We're not in the business of productizing our knowledge in an app or a tool. That's not, we've gone down that route and explored it and decided it's not really the piece in the place of the market that we want to play. But we could, right? What we do is we build things for our lawyers to use, who then deliver the advice more efficiently, quicker, more informed. And our clients are often involved in designing those systems that we use, but we don't tend to make them available to the client. But you could, right? You could have a world where you said to the client, we'll give you access to the same tool that lawyers are using. You can use it, get an answer quicker, but it doesn't come with our insurance policy. It doesn't come with, it's not legal advice, right? There's privilege questions and all those sorts of things as well, because the lawyer's not been involved in it. But within 24 hours, there'll be an SLA that will sign off on it as legal advice that is contextual to you and has had the quality assurance that comes with the, insurance. That's a huge opportunity for the market to change the way it operates. And if you think about it at the other end of the market, access to justice for consumer type issues and criminal type issues, huge opportunities to fundamentally, democratize access to the law in a way we haven't been able to do before, where none of us, well, there are obviously some complex issues, but most of us would say that is a positive and we should do that because the system does not serve that segment of the population. But those same principles could apply at the corporate end as well, ultimately, about getting access to things at a different price point.
I've heard the cost plus proposition before, where you're essentially pricing on margin. I think one of the challenges with that, though, is your costs are based on internal firm compensation decisions that your client might not agree with, right? Like your cost to deliver, if you have a partner whose cost is $1 million a year, and you're offering me, cost plus 20%, so then I'm essentially paying, that'd be roughly $600 an hour, US, right? Cost is roughly 5,000 hours. I'm sorry.
So say not quite 5,000.
Yeah, right. So the challenge though is that the structure of the internal firm compensation is going to have a huge impact on what that margin looks like, because this is a people business. So how might that work? Because it'd be really difficult to compare apples to apples, right? As a buyer, and say, okay, well, I'm going to pay cost plus 20% to, Baker McKenzie and law firm Y, but your costs may look very different than law firm Y.
Yeah, I actually don't think it's that different to what clients are already doing on the hourly rate. So if you look at different pricing strategies firms have on the hourly rate, you can have really high rates and offer big discounts. All right, you can have lower rates but offer lower discounts. If you're competing at the same quality level and bit of the market, they end up with the same outcome, right? Different structural decisions around how you price, but also different structural decisions about then how you resource that. You have some firms which have high leverage models, some firms which have low leverage models. Obviously, the technology is going to impact the high leverage firms, I think, more than the low leverage firms over time. But ultimately, you're right. There's a certain amount of engineering. But the other point to think about is actually those talent decisions are talent decisions that the firms need to do to compete to have the best talent in the market, whether it's getting the best people out of law school, now the best technical expertise. Try to recruit a computer scientist in the legal space at the moment without spending a lot of money. It's a very hard talent gap to fill. And even on the partner side, right? Yeah, part of what you're paying for is the ability to generate business and effectively a sales function that your rainmakers play. But part of it's also you need the best litigator, you need the best advisory privacy lawyer or the best employment lawyer if that's the area you're targeting. And so that's the cost of the product is a reasonable cost. That's what it's costing to get that talent to you. And I think one of the things that, again, we don't talk enough about in the industry is the symbiosis between the in-house market and the private practice market when it comes to how you train lawyers and provide a pipeline of talent to both sides of the market. Because at the moment, the majority of that talent pipeline, the base of the pyramid, starts in private practice. And that has a cost to it as well. And I think one of the things that slightly off topic, one of the things that we're thinking about a lot here at my firm is with some of the technological change, you might be able to reduce the cost, make it drive efficiency in the short to medium term. But some of the skills you need lawyers to have are not skills that are easily done outside of an apprenticeship model. They're hard to learn in a classroom. They are the experience of negotiation, being in the room, being in court. So you may end up in a world where actually you carry deliberately some inefficiency in the business still in order to make sure you have a pipeline of talent to sit at the top and do the really strategic stuff. That, again, is a cost that the client would say, well, that's your choice, not ours. And you go, that's true. But actually the implications of us not making that choice hit both of us, potentially at different points of time in different ways. And so, we need to think about what the implications are. Most firms already won't pay for first or second year associates, for example, because they regard that as training. But if you start cutting out that layer completely, in 5 or 6 years' time, it's going to be much, much more expensive to recruit a 6 or 7 year qualified lawyer into an in-house team as well.
Yeah, senior lawyers will be like COBOL programmers, right? Like,
Correct, exactly right. Good analogy.
Yeah, and what's interesting, so I spent 10 years at Bank of America. It's incredible how much private industry and government still relies on these skill sets, insurance, financial services, government, and there's a huge gap. People are being pulled out of retirement and making millions of dollars a year just because they understand that. And that same dynamic could happen here in legal if we totally nuke the leverage model. But, I've heard mixed, I've had some partners who've told me that about their journey, their partnership journey, and said that in the beginning, they were thrown in a room with a box of documents, and that wasn't effective training. It could have been much more effective, and the partner, the overseer in that equation would only come in when they had to. Whereas, this technology could open up new training mechanisms and, really reimagine the whole associate development process. Do you see opportunities there as well as potential
Yeah,
challenges?
huge opportunities. And I agree. Like, there's a certain amount of sort of camaraderie and being in the trenches that comes from being in that data room with thousands of documents and no daylight for days on end. But I don't for a second say that that was good quality training. But I do think being required to look for things of relevance and value in a mountain of information is good training in how to think what's relevant, how to ignore the irrelevant. Similarly, it's very rare that a young lawyer gets to draft a contract from scratch these days, right? And that is a challenge, right? Because actually, if you have to draft it from scratch and think about the issues that are between the clients and think about the things you need to cover, that makes you a better lawyer when you're looking at the 1,000-page contract for $1 billion service. And so we've got to find ways to give that sort of experience to lawyers if we want them to be, the strategic partner at the end of the day. I do think there's some opportunities to effectively get some of this technology to quiz our lawyers, to question, why did you do that? Have you thought about X, Y, Z? Those things I think are there. It's not my expertise at all. That's one of the areas I go to our learning people and development people and say that's firmly in your wheelhouse rather than mine. But there's definite opportunities there. And if I think there's one thing that we haven't cracked yet, that's it. If you think about how a service is going to be delivered, what a client's going to want, what does the end state look like for pricing? I think those are pretty simple, if I'm perfectly honest. I think there's a huge demand for premium and other legal services. It'll be filled in a variety of ways, and there's a pretty much big consensus as to what it looks like. The training piece is the piece I don't think anyone's figured out yet, and I think law schools are struggling with it as well. So it's not just firms either.
Yeah, they are. I've had lots of academics on the podcast, and it is a constant struggle. One thing you and I talked about last time that I thought was really interesting was the orchestration layer risk and avoiding having your law firm powered by tech companies, right? And I think that I'll give my take, and then I'd love to hear yours on this. So I think the whole powered by, I think that's a very short term risk, and the reason I think that is because the big players in the space today are very much, the model is bring your data to AI, right? The Harveys and the Goras of the world, they are mostly ad hoc. They're not doing wholesale AI operations for the most part, right? I see the future as being very much how law firms are going to differentiate themselves is by leveraging all of the documents and wisdom that created positive outcomes for their clients. And that is going to be baked into whatever tech-enabled legal service delivery machine gets built. So I think, but in the short term, it could be a risk, right? Why am I paying, X law firm $1,000 an hour who's using, this tool when there's a firm over here at $800 an hour? I think that is a short-term risk, but long-term, I think firms are going to have to do some R&D and if they want to differentiate. But I don't know. What is your take on that?
Yeah, look, I don't. I'll come to the orchestration layer point because I think it's an important one. But before I get there, the thing that's going to differentiate law firms at the premium end of the market is not the technology, right? Ultimately, every law firm is going to be using a mixture of the same tools, just like we do now, to be perfectly honest. And I don't think AI changes that. What's going to differentiate firms is, do you have the right human talent? And that's, across the spectrum of skills you need, but ultimately you're still going to need the best lawyers, both from an expertise perspective, but also a client handling perspective, a relationship trust builder, sales, those sorts of things are going to determine who wins. So you're still going to be going to law schools trying to recruit the best lawyers ultimately and train them up. And then the second piece is the piece you mentioned, which is, what data do you have within your business that is not available to everyone else via those models, right? And that unique play, and I've got some people who challenge me on that. They think that everything's going to be commoditized on the data side of things. That what is it that's really, really unique? You say no, but ultimately, you could say here are the rules. The what is the law business, that stuff's gone away, but the what do you do piece does vary depending on the lawyer you're talking on, your boots on the ground. If it's a country that is not as predictable as others. The world's becoming a more volatile place. Those sorts of judgment calls increasingly valuable if you get them right, around what you do, particularly around geopolitical risk. And so those are the two things which are going to differentiate. And so those are the two things you have to invest in. Now, what are the barriers to that? So one is client reticence to allow people to use client data in the design of those systems, right? And that's the reality. We still get that from sophisticated technology clients, right? You require consent for every use of my data in any AI tool. You go, well, then we can't build intelligence that goes across the business. We can do verticals for you, but ultimately you come to Ben as a technology lawyer because he's done work for you for years and knows what it is, but also because he works for others in the industry and has a sense of what market is and has a sense of what risk tolerances are from peers. And that can only come if we can work horizontally. And so that will come across the business, that will come. But then the second piece is that orchestration layer you're mentioning, because what has happened over the last 50 years is law firms have been the layer in the value chain where legal expertise, information, project management, technology have been brought together to deliver a legal service. And, over the last 20 years, in-house teams have started to grow their capability to fulfill that role. So, one of the alternative buying patterns was we'll build out a team to do this internally so that we become the orchestration layer and we just take the expertise out of a law firm for certain bits. ALSPs, 10, 15 years ago, started to come into the market and say, well, there's bits of this that we can take out and we can become the orchestration layer for that. And now your new sort of tech law vendors, because of AI, are playing for that space as well. So when I say, what's going to change is the orchestration layer, I still think there'll be a role for some law firms in that layer, but the winners will be the ones who can maintain a place in that orchestration layer because they bring something unique to the table when it comes to that data or the talent piece. If they don't bring anything unique, then they will become suppliers into one of those other orchestration layers. And the second you do that, then your margin goes, right? Because ultimately your margin gets squeezed for their margin. And so that's certainly from our strategy perspective, is to say we want to make sure we continue to deliver enough value that clients will see a role for us, in the orchestration layer and not have us powering somebody else in that layer. And that's on the assumption that most sort of tech vendors don't want to become licensed law firms, right? Legal service providers, but that could change as well.
Yeah, I was going to say, I would challenge that assumption. We're already seeing it here in the U.S. and actually in,
Yep.
There's a few examples. Crosby is a notable one here in the U.S. and they have a really narrow focus. It's what I know about them. Sequoia, who's one of the VCs in their cap table, had the founders on a podcast, and they talked about doing, I believe they do like MSA review for some of the big SaaS players in the space like Clay and Stripe.
Yeah.
I think that, and I'd be curious of your take on this. I think it's a really interesting time to be a challenger firm right now and building from the ground up without all of the legacy baggage that a traditional law firm structure has. And by legacy baggage, I mean, the internal firm, lawyers are ruthlessly measured on billable hours, really hard to change that culturally and otherwise. The partnership structure itself, the consensus driven decision making, the cash basis accounting that optimizes for profit taking at the end of the year instead of long-term investment. Retirement horizons, the lack of a traditional C Corp governance model where you've got shareholders and you got layers of risk management that you see in traditional enterprise structures. None of that exists in law firms. And I think it's going to need to exist in the next iteration. So I guess two questions. One is, do you agree with that in 5-10 years, whatever the number of years is, or are we going to need to look fundamentally different than we do today as an industry? And then, what is the viability of a challenger firm kind of coming up the ranks, starting with a narrow niche and, maybe a 10-person AmLaw 50 firm one day? I don't know. What are your thoughts on those two questions?
Yes, I mean, every sort of challenge that you identify is true, right? And there are trade-offs made throughout. So there's a reason that most legal systems still require law firms to be partnerships, right? Alternative business structures are coming, but actually it wasn't, the requirement to be partnership structure was because of the fiduciary relationship with clients and the profession. So there is a trade-off. Once you move away from the partnership structure, and that impacts the fiduciary relationship, and policymakers may decide to change the rules. But one of the things I'm quite vocal about, I gave evidence to the UK Parliament about this, is, let us compete on an even footing, right? If somebody can deliver something technology enabled, but without having to have all the fiduciary duties that come to consider the client's best interests, then if you want us to compete with that, take that off the law firms as well, right? Or alternatively, put it on the other side so that everyone's, achieving the right policy outcome here. So I think, that shift is going to take a while. The regulations will take time to catch up, which is why it has to be very narrow at the moment, because it has to be in areas where policymakers have decided it's okay and jurisdictions where they've decided it's okay. And so for a business like ours, which is already in 45 plus countries and jurisdictions, it's going to be messy, is the honest answer. We can't just flick a switch tomorrow and change the structure, because, it comes down to things like in some markets, we have to have a founder's name in the firm name that is registered with the bar there, so we can't be Baker and McKenzie there, right? And people go, oh, it's a different firm. No, it's like, yes, it's a structural change, but the rules require us to have a different structure in that market in order to practice legally. So the change won't happen sort of uniformly, but of course, the bigger firms have more resources, and so therefore you would have thought we'll move faster. But again, as the cost of entry goes down with technology, it could well be the case there'll be a challenger firm. I haven't heard about the sort of 10-person AmLaw sort of 50 firm, but the first single principal, $1 billion revenue firm is something people talk about quite a lot. Is it possible? Yeah. But then the piece is, the big four have all at various points in times made forays into legal and invested heavily at various points in time. And, one of the challenges they have, even with their resources and their more corporate structure, is, delivering what clients want and retaining the talent they need to deliver what clients want to play at that sort of big end of the table. And that's part of the challenge as well, right? It's one thing to say, okay, more corporate structure, but can you keep the humans in the mix? And as I said before, humans are going to be part of the sort of solution to the top quality product, without some of the status, without some of the autonomy that they've been used to in a private practice partnership model. And in some organizations, they'll crack the magic formula there. I think most won't, to be honest. History dictates it's a little bit harder. And so, I think for more process-driven or process-amenable, I should say, service lines, then yeah, that's where I see the market going. For the more artisan bit of the market, I think you'll still see a partnership model surviving for quite a while.
Well, and the big four are partnerships as well, and they have their own baggage. I think what makes them different and potentially a real threat in the space is they have innovation in their DNA, and law firms generally don't. That is starting to change, but we got a long way to go. Again.
Look, I accept that. I mean, you don't. Most industries which are innovative don't tend to have people who have titles of chief innovation officer, as a rule, right? It's a fair signal. It's a fair signal that you're starting from somewhere further back on the field.
Yeah.
But equally, I do think the shift has started. I think it started some time ago. I think the narrative of law firms having their head in the sand actually a false one. I think actually most good leaders amongst law firms in the industry get it. But coming back to a point we raised earlier, you need client demand to change their buying patterns. It's a bit like sort of inclusion and equity programs and those sorts of things as well. It's like if you want to achieve an outcome, this is before our current age of politics, you need to change how you buy. Ultimately, if you want a more diverse supplier and you still buy from the white males, right, then you're going to get the white males. And the same is true around innovation, right? If you want innovation, you've got to reward or at least take a risk on those businesses who are saying, let's do it a different way. And I think that's starting to happen and will happen more and more. But that ultimately is what will drive the change.
Yeah, and I agree with you. By the way, I do think that it is changing. I don't think that most of what I would consider successful firms out there have their head in the sand. I do think that they're moving slower than maybe I would if I had, and I understand there's a lot there's a lot of baggage that has to be managed on this journey. And it is, I find it interesting that, and I look for early signals because what we do is is very aligned to firms who think in an innovative way. We're putting our chips on the table that we're an intranet extranet platform. Intranet, yeah, there's some innovation there, but extranet is a scenario where we believe that the clients are going to demand a different journey in how customer journey and how they engage with law firms as we undergo this transformation. So that's where we're putting our chips on the table. And one signal that I've seen pretty reliably predict the commitment to innovation is the hiring. Just look at the people they're bringing in. I mean, you're seeing a lot of big four folks, McKenzie folks now move into legal. You're seeing, I think, the org chart and the commitments that firms are making to these hires. Because think about it, if you're, like Liz Grennan at Simpson Thatcher, she's got a big name in the space and very well respected. Why would she make the move from McKinsey into a law firm if she wasn't real comfortable that she was going to be given the tools to succeed there? So I have no knowledge of what's going on there, but I just look at early signals on the hiring. Is that a good predictor, or are there other things that maybe clients or people should look at to I guess try and predict winners and losers of this transformation?
Look, I mean, I think, yeah, the talent that's being hired, I think, is important. And, we've done that for a few years, been looking at sort of who's hiring what type of talent. Doesn't always work out. There's a bit of a revolving door of some of those sorts of roles, and that's the reality, right? And some of the reasons are the barriers that we've been talking about here, that they run into a challenge. And yeah, we've recruited some super talented people into our business who haven't been able to navigate some of those barriers, and through no largely fault of their own, to be frank, have decided this isn't the right place for them. Even though I think we are one of the more sort of progressive when it comes to that sort of structural piece, just given how complex a business we are anyway. No, I mean, the other thing I would be looking at are the core metrics, right? Ultimately, the numbers going in the right direction, and there will be a bit of a period where the investment cycle will require a bit of a dampening on profits per partner for a few years. But if you start to see a pull away from firms who get scale, continue to increase scale, but also maintain margin, I think that's a fairly good indication they're doing something different, because there's so much competition. There'll be so much competition that if you can't do that, if you can't reorganize yourself, then you won't win. And I think that I said at the start, I think there's definitely still going to be a market for premium legal services and legal services generally, but there will be winners and losers. And I think the AmLaw 50 will look very different in 10 years' time to what it looks like now.
I completely agree. Yeah, and the financial metrics, I agree with you. They're a bit lagging. I think it's hard to find leading indicators. Again, because you certainly can't. There's a professor at Northwestern who created a law firm innovation index, and the approach was to go crawl the law firm's websites and find things that seem to be leading towards innovation, AFAs. Anyway, you can't, there's a huge disconnect between what's being said that from a marketing perspective and what's actually being done.
Yeah. And you look at that, like the products that everyone's announcing, the partnerships here, deals there, licenses taken. The next question is, what are you doing with it?
Right.
Right. And I do think there's a lot of innovation by press release that happens in the market. I'm not going to, for a second, claim that we haven't been guilty of some of that, where you're competing with the market that you're facing. Clients want to hear stories, but the actual changing of process and the data and the behavior needed to actually affect real change is hard work, as we all know. And I think the reality sometimes is different from the press release.
Yeah, and that has been especially true pre-Gen AI. I think it is catching up.
Well, I think Gen AI is a general purpose technology, and that's the big difference, right? So everything up till now has largely been application specific, and that has an impact, but it doesn't cut across the entire functioning of the organization, and also your client's organization as well, right? That's the difference here. It's not a perfect analogy, but effectively, it's look at the productivity jump in legal when email came in. You didn't have to wait for a letter for 7 days to execute things. We're looking at that sort of productivity jump, and that unavoidably impacts the economics.
Or digital legal research,
Correct. Correct.
Another
exactly right.
huge innovation. Well, this has been a great conversation. I really appreciate you carving out a little bit of time to have a chat. I know my listeners will certainly enjoy it. How do people find out more about maybe writing or speaking that you do and the firm?
So follow me on LinkedIn is probably the best way. I tend to be fairly assiduous at publicizing myself on there, and that'll connect you to most of the right people that I'm connected to on this side of the pond. But thank you for having me. Really enjoyed it.
Awesome. Okay, we'll chat again soon. Thanks, Ben. Thanks for listening to Legal Innovation Spotlight. If you found value in this chat, hit the subscribe button to be notified when we release new episodes. We'd also really appreciate it if you could take a moment to rate us and leave us a review wherever you're listening right now. Your feedback helps us provide you with top-notch content.